Hello everybody, and welcome to the first CIPIL seminar of the year. It is my pleasure to introduce to you Dr. Harn. Harn is a lecturer in intellectual property law at the University of Sheffield. She previously used to be based here in Cambridge, where she wrote her PhD on the topic of copyright issues surrounding the modification of video games by players. Is that right?
Yes.
And she is back here today to talk to us about the concept of copy in copyright. So I won't bore you anymore. I think we can go straight to Harn herself and hear her interesting ideas. Harn, the floor is yours.
Thank you, Christina. Thanks for having me here. I don't know how interesting they will be. So let's just try to moderate expectations slightly. I will try, but I can't promise anything. Right, so I'm going to begin by saying something we all know, which is how broad the scope of the right to copy a work or the right to reproduce a work. There may be some interesting semantic difference there, which I'm not going to really go into. But the scope of the right is very broad, to the point where I think the question of is this a copy is not really a meaningful one in most circumstances. For instance, if I were, for inscrutable reasons of my own, to decide to copy the entire volume of the 5th edition of Bentley and Sherman and on intellectual property law by hand, it would not be a defense for me to say I haven't copied. I would have to rely on some other defense or throw myself on the mercy of the copyright owners. So, given this situation, I think it's safe to say that most things that are a copy in the technical or literal sense are also copies for legal purposes, for the purposes of copyright law. The concept that could be something that is technically copying, but it's not the type of copying that the law ought to be concerned about, I think, is no longer a meaningful limitation on the scope of the right. So the aim today is to show that, at least historically, this was not always the case, and what the implications for that are for our current understanding of what copying should be. So in the pre-modern period, which I'm vaguely using to refer to in the period before the coming into force of the 1911 Copyright Act, the courts in the time before this did not treat all acts of copying that were technically or literally copying as copying in the literal sense, as copying for legal purposes. So in other words, they have not, when faced with the question, is this copying, they have not always just resorted to the literal or dictionary definition of copying and based their answers on that. Rather, they took in a number of cases, they took a more nuanced approach, which I will suggest reflect two sets of considerations. First, the extent to which they thought the right holder was entitled to extract value from the work. And to the extent that the right holder was entitled to extract value, that was, if you did that, that was the act of copying. If it fell outside entitlement, it was not copying for legal purposes, even though it might be copying for technical purposes. And the second, perhaps to some lesser extent, but that will be for reasons which I'll explain later, there's some idea that in defining copying, it should be limited so as to allow some degree of space for personal uses of works. And this was especially the case on artistic works because of the way in which the right was defined in relation to artistic works. So, in other words, in the pre-modern period, the courts were able to interpret the notion of copying with some degree of flexibility to account for some of these interests in ways that a contemporary court probably would not be able to. So, in a certain sense, this thing that I'm trying to do sits alongside existing scholarship by, for instance, Kathy Bowery and Isabella Alexander, who have shown how judge-made concepts like fair use were deployed in flexible ways to strike a balance between between copyright and the public interest. And to quote Kathy Bowery, this exercise involved a relative consideration of the original efforts and corresponding markets of the parties involved in the case. So the idea behind this will be to show that the courts also took a similar approach and took into account similar considerations in interpreting statutory language surrounding the words copying and multiplying copies, because those were the words used in the statute. Now, there are not many cases on this, to be very upfront about it, because the question of is this copying usually only arises when the act of copying has taken place in a somewhat unexpected way, through a means that you would not normally expect to find in the field. So because there are not many different ways of duplicating works back then, this was not a question that came up very frequently. It was especially not a question that came up very frequently in the context of printed works until towards the very end of the century, the 19th century. And I have to admit that some of these cases are not as clear as I would possibly like them to be, because the question of is this copying was often bound up with the question of is this copying of the work? And sometimes it's not clear whether the courts are saying this is not copying or whether it is not copying of the work, or whether to them it was more or less the same question. Okay, caveats aside. The first of these cases is Gambart and Ball, 1863. I'm sure all of these cases will not be new to most of you. So the work in this case was an engraving, this engraving by William Henry Symonds, and this was an engraving of a painting by William Holman Hunt called Light of the World. And the alleged infringement here was that a defendant had taken photographs of this engraving and offered them for sale. The operative statute here was the 1777 Engravers Copyright Act, which, if you see, says after a long list of acts, if any person in any other manner copy the engraving, then that would be infringement. The counsel for the defendant tried to argue that although the photographs were copies in some sense, they were not copies within the meaning of the statute, because they were directed at a different market and at a different class of purchasers. Normally, they would be cheaper than the engravings. So, the idea was that if you couldn't afford the engraving, you would buy the photograph. And I think it's interesting to see that there was engagement from the judges in these terms to decide whether or not this kind of copying was the kind of copying that was meant by the statute. In the end, they found in favor of the plaintiff and against the defendant. Chief Justice Earle said, a photographic copy may excite in the mind of the beholder the same pleasurable emotions as communicated by a copy of any other description. So basically, the function or purpose of the photographic copy was the same. I mean, as any other type of copy, perhaps an engraving. You might disagree or agree on that, but that was that was the view that his judgment was based on. And he said, because of this, I cannot help thinking that the value of the plaintiff's property, in this case the engraving, would be sensibly diminished if the multiplication of copies by means of photography were held to be lawful. It seems to me that the making of copies in that way and selling them is within the words as well as the mischief of the act. So even though the act did not say it was infringement to copy by photography, this was analogous to the types of harm that the act had in mind, because the photographs would reduce the value of the plaintiff's engraving. And you can see a similar kind of consideration in the judgment of Mr. Justice Wills. Now, interestingly, according to the case report, the different judges asked counsel for both parties, do you think if somebody copied this engraving in pen and ink, would that be a copy within the meaning of the statute? Would that be copying for legal purposes? What if he then sold this pen and ink copy? Would that be all right or not? So obviously, counsel for the claimant said, yes, a pen and ink copy would be a copy, and counsel for the defendant said, no, it wouldn't be a copy for legal purposes. Sadly, this question was not answered fully, but it did seem to bother Mr. Justice Wills. He seemed to find very uncomfortable the idea that the statute and the idea of copying could be interpreted in such a way as to stop an individual making a pen and ink copy. So this is how he reasoned it out. He said the statute, this is how he interpreted it. He said, I think the statute is capable of being explained so as to include any process in the arts, the result of which is to produce an indefinite number of copies. And it applies to copying by any process by which copies may be indefinitely multiplied. The act need not be construed to extend to a copying by hand. So copying, photographic copying was copying for the purpose of the statute, but copying by hand seemed not to be. The second case is Dix and Brooks. The perhaps slightly unfortunately named Dix in this case was the editor of a periodical called the Bow Bells. This is one of the covers of one. It is not the one at issue in this case, unfortunately, because this is an 1865 issue. For the Christmas edition of one of these magazines, he published a pattern for Berlin woolwork, which, as far as I can work out, is basically a form of needlepoint. And the pattern was based on this engraving by John Barlow of a painting by John Everett Millais called The Huguenot. And because it was Berlin woolwork, it was, as the case report describes it, rendered as a mosaic built out of small colored squares. So this is a Berlin woolwork pattern from more or less the period is from around 1850, so that gives you an idea of what it might have looked like. And Dix changed the background of the image so that it showed, quote, a Chinese Gothic castle in the background, which, I mean, I'm not quite sure what that would look like. And I think the colors of the dress were a bit different from in the painting. But anyway, this is not a very good case because you can read it and it's now read as a case where the alleged infringement, which is the Berlin woolwork pattern, did not copy the work in this case, which was the engraving, because it did not copy the lines and the stripes and the dots that made up the engraving, and it's read that way as well. And that was one of the arguments in this case. Of whether the Berlin woolwork pattern was a copy, or whether in printing the Berlin woolwork pattern, Dix had copied the engraving. So again, it's not a great case, but in addition to suggesting that perhaps Dix was not copying the engraving, but only the painting behind the engraving, which at the time was not protected by copyright, the court also considered the purpose of the engraving and the market for the engraving, and they found in favor of Dix, so it was not a copy. And this was based on the same statute. And Lord Justice Bagley said, when the statute says engraving, etching, or working, or in any other manner copying, it's perfectly clear that those words must receive some limitation, for they cannot have been intended to apply to a lady copying a print or a part of a print upon a china plate, or to a person who, for his own amusement, makes an etching, drawing, or watercolor sketch from an engraving. So basically, we have to take a purposive interpretation to copying, because clearly there are some things which the legislature cannot have meant to exclude from the scope of people's normal activities. Lord Justice James focused on the purpose behind the engraving and the different purpose behind the Berlin woolwork pattern, and said nobody would take the pattern to be the print, nobody would ever buy it instead of the print. It is a work of a different class, intended for a different purpose. And Bramwell, Lord Justice Bramwell said, made a similar point, and said what the legislature had in view was a new engraving or something which could be taken as an engraving or an equivalent to it. So in other words, a substitute for an engraving, which this Berlin woolwork pattern was not. Third case, I'm going to call it Empire Palace because I'm very bad at names that are not in English. So this is about, tableau vivant, or living pictures. This is what Victorians did for entertainment. So this was people dressing up, mainly actresses. And you'll see why in a bit. Actresses dressing up as figures from classical paintings and then posing in the attitude of the subjects of those paintings. And then people, usually with the backcloth to simulate the rest of the painting. And then people would come to watch these people standing completely still in those poses on the stage. There's some suggestion. The popular ones tended to be based on classical figures. So you mainly had very lovely women dressed in not very much, standing on the stage, and men, and I suppose women who were attracted to women came to see them. So in other words, it was the Victorian Game of Thrones. Say you're watching it for the plot. So at issue in this case was whether if you staged a living picture, you were copying the painting behind the picture. The picture you were trying to simulate. And at this point, paintings and pictures were protected by copyright. And this was a relevant statute, Fine Arts Copyright Act of 1862. The author shall have the sole and exclusive right of copying, engraving, reproducing, and multiplying such painting or drawing, words which seem quite broad. Again, this is not a great case because you might just as well argue that, well, this is not copying, this is a performance, and we need to look not at copying but at the performance, whether it's a performance or not, and that featured to some degree in the judgments. But then they also talk about the purpose behind the Fine Arts Copyright Act and what they expected, what kind of harm they expected that to target. So Lord Justice Lindley says Parliament was not endeavouring to lay a totally different class of people under restraint. It was not dealing with or intending to limit the scope of a sculptor's business or of an actor's business. It was to protect painters and persons who produce drawings and photographs from having the commercial value of their productions impaired by the reproduction by any means of something of a character similar to that of which they were the authors. That is key to this act. So it's not to stop actors doing appealing to the more prurient senses of the Victorian public. It was to protect painters and people who made drawings and photographs from having the commercial value of their productions diminish by something that was like what they had made. And he goes on to say that the plaintiffs would have them say copying and reproducing by any means in the statute includes reproducing in the sense of imitating or representing by means that are not equivalent to drawing or painting or photography. And he says plainly the statute is not aimed at preventing this kind of activity. It is intended to protect the author from anybody producing a painting, drawing, or photograph of his picture so as to compete with him in the market. And this kind of representation was not competing with him in the market, therefore it was not a copy. Final case is Boosey and White, which again is not a great case, I keep saying that. This is 1899, involved the Aeolian organ, which was an early form of player piano. So do we still have player pianos? It's basically a machine. It plays music automatically if you put in a sheet that consists basically of holes punched out so that the machine knows what noises to produce when. And the argument was was that the plaintiff in this case was a music publisher, and the argument was that in producing those perforated sheets, the sheets with holes that go into the machine, the defendants were making copies of the plaintiff's sheet music. Now again, this is I'll do this first. So the operative statute at the time was the 1842 Copyright Act, which says copyright shall. This is interesting because the definition section says copyright shall be construed to mean the sole and exclusive liberty of printing or otherwise multiplying copies of any subject to which the said word is herein applied. But if you go to the infringement section, it says it begins with if any person shall print or cause to be printed any book in which there shall be subsisting copyright. So obviously, otherwise multiplying copies is a phrase that's capable of a broader meaning than just printing or causing to be printed. But anyway, most of this case was focused on the first part, and especially the phrase otherwise multiplying copies. So the question was whether in producing the perforated sheets, the Aeolian manufacturers were multiplying copies of the plaintiff's sheet music. And again, the reason this is not a great case is because you can also read it as a case about have the defendants copied the work. And if you say, as I have argued before, that the work is the sheet music consisting of the staves and the notes, then even if the defendants have copied something, it's not the work that they've copied. But you could also read it as a case which says that the defendants here were not copying. And the reason I think you can have this reading is because the commentaries at the time agree that if you take a sheet of music written in the conventional way with staves and notes, and you rewrite it in solfa notation, which is to say you write it as do, re, mi, fa, sol, or if you do it in Braille, for instance, then that would be a copy of the work. I mean, there's no case about it. There is a case that suggests that shorthand characters may be copying of a literary work that's rendered in the normal way. But there's no case about this music thing, but commentators of the time seem to think so. So here, the court took the view that the perforated sheets were not copies of the sheet music, and the reason was that the perforated sheets were used for a different purpose compared to the sheet music. Lord Lindley, at this time the Master of Rolls, says the idea basically that a sheet of music, the purpose of it is to be read by a person who can read music and to play and sing from it. The perforated sheets were meant to be used in conjunction with the Aeolian organ. And he says, conceding for the sake of argument that even if a person could be trained to play or sing from the sheets, it is clear that they are not made to be so used, nor are they ever so used in fact. And we ought, in my opinion, to deal with the case on broad business lines and not on unpractical, though theoretically possible assumptions. Lord Justice Romer says, in no practical or substantial view can the defendant's sheets be regarded as copies within the meaning of the act of the plaintiff's sheets of music regarded as books. The plaintiff's sheets and the defendant's sheets are issued and used for substantially different objects. The plaintiff's sheets are issued and used as books to be read. The defendant's sheets are issued and used not as books to be read, but as parts of a mechanical musical instrument to produce the sounds of music. So far, not very good cases, but there seems to be a pattern here of the court saying this is not copying because you have not made something that competes with what the plaintiff has made or that diminishes the market for what the plaintiff has made. And these market considerations were also a common feature of other cases, mainly on literary copyright, about whether if the defendant had taken part but not all of the plaintiff's work, whether that was a fair use, and it was a fair use, then it was not an infringement. And especially in the earlier period, one of the ways of deciding whether the use was fair or not was to look at what effect the defendant's copying had on the value of the plaintiff's work. So this is reflected in, this is an extract from the second edition of Coppinger on copyright. And he says, regard must be had to the value of the work and the value and the extent of the infringements. Although the law allows a man, also a woman, also a non-binary or a gender person, to profit by all antecedent literature, yet the use made of such antecedent literature may not be so extensive as to injure the sale of the original work. The main point must always be what effect will the extracts have upon the original work, how far will they supply its place or injure its sale. So that I suggest was also consideration in the cases that we've seen as to the definition and interpretation of copying. And in the first two cases, the ones about artistic copyright, I think there's also a sense that the word copying must be defined so in a limited way so as not to interfere too much with personal uses of works. So the lady painting her china plate, the person, no gender specified, copying a sketch or a painting for their own amusement. This is something that's been pointed out by Eleanor Cooper, where she highlights that the debates around artistic copyright were receptive to ideas about the private uses of artistic works. She refers to what the barrister Thomas Scruton, who was also advisor to the Royal Academy, said to the House of Lords Select Committee on Copyright in 1898, where he says, "I do not think that copies made merely for amusement are at present an infringement of copyright." And a comment from Solicitor Basil Field to the Royal Commission on Copyright of 1878, "When gentlemen have bought watercolour drawings, very often their daughters like to copy them." So there was a sense that copying, this kind of personal copying, was a normal thing and was generally a neutral to positive thing. It was not seen as a negative thing. And I think part of the reason that artistic copyright had to grapple with this question is because artistic copyright has from the beginning been defined in a medium neutral way. Because the copying of artistic works generally may involve a change of form. So most of the early artistic work statutes would mention for instance, is an infringement to engrave, etch, etc., or otherwise copy, to capture other forms of copying. They were not the mainstream ones. And this was not the case with literary works, because from at least until maybe 1888, for reasons which will be explained later, of course, literary copyright has always been defined by reference to the right to print or reprint, and print or reprint wouldn't normally capture personal uses. So, 1888, I mentioned that, and this case gives an example of what happens when a court doesn't adopt a purposive approach to copying and just resorts to a literal approach, where it doesn't think about what kinds of concerns should be reflected in the interpretation of copying and just says, well, does the dictionary say it's a copy? If it does, it is. So this is Warren and Seaborn. The plaintiffs are Warren, who are publishers of this book, Francis Hodgson Burnett's Little Lord Fauntleroy. Seaborn was a playwright. He wanted to dramatize this book. And at that time, it was not an infringement for playwrights, at least for anyone, to dramatize a novel, because novelists did not have the right of public performance. So the right extended to dramatic compositions. They were intended from the beginning to be performed, and to musical compositions, but not to novels, not to literary works. And this is very clear from the commentaries at the time, that they normally phrase it as the dramatist is free to dramatize novels. So Seaborn wanted to dramatize this novel. He wrote to I'm not sure if she's Hodgson Burnett or Burnett. I'll say Burnett, it's easier for me. He wrote to her to say that he was going to do it. And she wrote back and said, I would rather you didn't, I'm doing my own. And he said patronizingly, dear lady, you can't stop me, basically. I'm going ahead with this. And so he did. Now, in the process of dramatizing, it was not very well received, his dramatization. It was staged, I think, but it didn't receive a great reception. So now, in the process of staging this play, he had either written by hand or typewritten 4 copies of the script for the play, 3 for the actors, and 1 to be sent to the Lord Chamberlain, who needed to approve all plays before they were staged. So the complaint was not that he had dramatized the novel, because there was no exclusive right for the novelist to dramatize. The complaint was that he had multiplied copies of the novel for the purposes of creating his dramatization. Seebohm argued that this shouldn't be regarded as an infringing act because he was doing something that was incidental. He was making copies that were incidental to what he was allowed to do, which is to dramatize the novel. And another reason I think he gave was that the number of was not reprinting, and the number of copies were very few. This did not pass muster with Mr. Justice Sterling, who took a very literal approach. He said the statute confers on the author the sole and exclusive liberty of printing or otherwise multiplying copies of the book. And subject to this, every person is free to make such use of the book as he pleases. So as long as Mr. Seebohm does not print or otherwise multiply copies of the novel, which in this case included writing them out by hand or typewriting, any person may dramatize it and may cause his drama to be publicly represented. But if for the purpose of dramatization he prints or otherwise multiplies copies of the novel, of the book, he violates the rights of the author. So you can dramatize somebody else's novel as long as you don't multiply copies of it, which in this case includes 4 handwritten copies. So the question is, how exactly are you supposed to dramatize the work? You can't even. I think it's a possibility. You could buy 4 copies of the book and then write a script that mainly says, please turn to page 81, paragraph 3, read this dramatically. But it would be very impractical, and second, I'm not sure it would, pass muster for censorship purposes. I'm not sure the Lord Chamberlain would approve. So effectively, this gave novelists a right that they did not have under the statute. Because if you wanted to dramatize, you would have to, at some point, do some copying. And under this judgment, to copy, you can't do that copying without seeking prior permission. So essentially, you can't dramatize unless you have got permission. Strangely, I think most commentators did not pick up on this aspect of the judgment, except Edward Cutler. He says this decision only shows that a logical and liberal interpretation of the law may often be opposed to common sense. If the representation of a play constructed from the novel of another is no legal wrong to the novelist, how can it be seriously said that the making of a few copies for stage purposes interferes with the sale of the book? So that's the example of what happens if you are too literal and you don't think about things that other courts have thought about when they've thought about what copying means. After the passing of the 1911 Act, this sort of thinking that copying doesn't just mean copying literally, it means certain types of copying but not others, bounded by some sense of allowing personal uses and some sense of the limits of the right holder's market. This sort of thinking started fading away quite quickly after the 1911 Copyright Act. The Act defined copyright in broad terms as the sole right to produce or reproduce the work or any substantial part thereof in any material form whatsoever. So that makes it sound a lot more broad but not that much broader than the statutory language used before. So courts often, I think, seem to have assumed that this means that the question of is this copying did not matter so much. And when confronted with copies that involve a change in form, they mainly referred to this part of the statute and said, well, this, under the old law, this might not have been a copy, but under the new law, this is copying because of the very broad way in which it is defined. And you can see this in Barbary, Agnew, and Company and Day. This was another case about living pictures, tableau vivant. And but the key difference was decided after the passing of the 1911 Act. So Ms. Justice Coleridge says, in this case, the living picture was copying, was a reproduction, and therefore infringing, because the 1911 Act had the effect of making living pictures possible subjects of infringement of the copyright in a picture, thereby remedying the effect of the decision in the Empire Palace case, which is an interesting choice of words, that it was a defect that needed to be remedied. And this was the main thrust of the decision. He then found the facts that the actual living pictures in that case were not, except with the exception of one, they were not sufficiently like enough to be reproductions. But the point is that he did not engage with the other points raised in the case as to what was the aim of the statute and what was the right holder's market, and did this kind of activity really diminish the value of the work. And also, I need to find this out, but I'm pretty sure that at some point around this time, people were doing tableau vivants at home. Society ladies were having parties where they dressed up very elaborately with very elaborate backdrops and staged their own tableau vivant in their home. So suddenly this made all of those things in potentially infringing copies. Okay, this is a good one. So more than 50 years later, we have a similar kind of thinking, right? If copying, if something is literally copying, then it is copying for the purpose of the law, without regard to what the effects of such a decision might be. So this is Bookmakers Afternoon Greyhound Services and Gilbert. Bookmakers Afternoon Greyhound Services produced a race card, which was held to be protected by copyright. It's not very fun, but it was. So Gilbert ran a series of betting shops, and in those shops he had televisions that received that received the broadcast, and the broadcast. One of the broadcasts featured race cards by Bookmakers Afternoon Greyhound Services. He needed a license to receive that part of the broadcast, for which he needed to pay bookmakers, not the person providing him with the broadcast. But anyway, bookmakers' argument was that in having the broadcast that showed their race card on the televisions in his shops, Gilbert was both publicly performing the race card and copying the race card. So on the copying point, this is what Mr. Justice Aldous said. So the applicable act was the 1956 Act, does not contain, which is structured similarly to 1911 and the current one, does not contain any different definition of the words material form, but I see no reason to give them a meaning which will exclude materialization on the television monitor. That being so, I believe that Gilbert, by turning on the television monitor in the shops, has reproduced a substantial part of the advanced program, which is the race card. First, he didn't need to do this. He had already, in the next paragraph, he holds that Gilbert had publicly performed the race card, so Gilbert was liable anyway. But this is a very literal approach to reproducing something on the television monitor, an act of copying. And this was not something that took into account, does this diminish the value of the race card? Or does it affect what other people might be doing in the rest of their lives? Because if this is the law, then any person turning on a TV that just happens to feature copyright work on the screen is suddenly committing a potentially infringing act. And this is 1994, so it was before the Information Society Directive. There was no exception permitting temporary copying for lawful use. So this made a lot of people infringers, but nobody noticed it at the time. Right. So, where's the point of all this? Well, the point is to ask, I think, if the considerations that were present when the pre-1911 courts were thinking about what copying meant and did not mean, are those considerations, are those considerations valuable, which I think they are, because let's face it, if they're not, then there's no point in my doing this paper. And are they still reflected adequately in the rest of the copyright system? So concerns about does this act affect the right holders market? Does this act leave does this interpretation leave space for personal use? I think those are now, to the extent that they remain in the copyright system, they are reflected mostly in the exceptions. We have the fair dealing exceptions, allowing some commercial uses, some personal uses. We have a very, very specific set of exceptions that allows you to record broadcasts for the purposes of time shifting them for private and domestic purposes. We have exceptions relating to temporary copying. And on top of that, we have now the three-step tests as set out in the Information Society Directive, which says that exceptions and limitations must not conflict with a normal exploitation of the work or unreasonably prejudice the legitimate interests of the author. So there's some idea of where's the author's market, where the extent of the author's entitlement, but this approaches it from the other side, assuming that anything that involves copying is prima facie something that is within the scope of the author's entitlements. So obviously there are a lot of gaps that are not addressed, and there are a lot of gaps on personal use. Also, if you place all these considerations on the exception side of the system, you are putting a burden on the defendant to make them out instead of on the claimant to show that there has been an operative act of copying. So fair dealing is quite limited. I mean, it's less limited now, but it's still quite limited because there are a lot of uses that you engage in on an everyday basis that the permitted purposes wouldn't capture. There's no general exception for private copying now. There kind of was one, but now there isn't. And what is striking, I think, is that the act of personal use that the judges were concerned about in those 19th century artistic work cases, it's not clear that they would be allowed. So you're painting things on a china plate, you're copying a watercolor drawing that your gentleman father brought home for fun. Those don't seem to be captured unless you can show that they are educational or private study in some way. And maybe that's the biggest casualty of all this expansion of copying, fun. You can't do that anymore. Mm-hmm. And a very specific thing that has always bothered me is if somebody creates a derivative work based on an exception. So say they have made a parody in reliance on the parody exception, and they put it online, and I want to look at it, so I download it. Am I infringing copyright of the work that the parody is based on? Because I'm copying a substantial part of that work, but I don't have the purpose. I don't have the right purpose. I'm not doing it for parodic purposes. I'm doing it for entertainment purposes because I want to look at it. Like where does that fit in the system? And on the commercial use side, that is also a question I have, which is, if someone has made a parody and the publisher decides that they want to publish and distribute it, can they, are they allowed to? Because the parodic purpose doesn't extend to them. They are doing it, the publisher is doing it for profit purposes, not for parodic purposes. So I'm still working out the full list of commercial uses that can no longer be engaged in now that we no longer have a robust approach to the idea of copying. But I think a very easy example is a whole bunch of technological uses, search engines, text data mining, digital indexing and archiving projects like Google Books, reverse engineering. And it's often said that They should be allowed because they are non-consumptive or non-expressive or non-display users of works, or not users of works as works. But I think it makes sense, for me, it makes sense to think of it also as activities that would not be considered copying if we had stuck with a robust interpretation of copying. You can see this in quite a lot of the recent literature, and you can also see in the Hargreaves report, which kind of gets at some of these ideas. They said the Hargreaves report says this is not about overriding the aim of copyright. These users do not compete with the normal exploitation of the work itself, and that these new users happen to fall within the scope of copyright regulation is essentially a side effect of how copyright has been defined, rather than being directly relevant to what copyright is supposed to protect. So now I've always found these types of arguments tricky to deal with intellectually, because it's in an environment where every act of copying is presumptively something that the copyright owner is entitled to control. It seems that it's very hard to make the argument that if you stop them from doing that, if you stop them from controlling that, you are not depriving them of some sort of revenue or some sort of rights. But if you flip the question around and say, let's look at it, and if we start from the premise that we cannot assume that all acts of copying are acts that the copyright owner should be entitled to control, then and instead the burden should be on the right holder to show that it actually harms the value of their work, then for me, intellectually, it's much easier with that shift in perspective to start to understand why these kinds of uses should be permitted. Now, as to what we do, which is the last bit of this presentation, I think it's sadly too late to roll back the tide on what is and isn't copying. But having an understanding of, but this way of looking at the evolution of copying highlights the scale of what we need to do to counterbalance the very broad right that we now have. So clearly the exceptions that we have now got are not enough. If we want to have a sensible counterbalance, if we can't tinker with the right, we can't tinker with the concept of copying, we've got to tinker with having more exceptions to balance the broad right. I'm not sure that exceptions are the best vehicle to deal with this. I think, for instance, in the US, the doctrine of fair use has had to do a lot of work, perhaps in ways that it may not be suited to, simply in order to try and contain the broad scope of the right to copy. But this seems to be what the tools that we have at the moment, so we're going to need to do something about them. There's also one final bit, which is that there is one area on which we can push back on what copying is or isn't. I think it's still live enough for us to do that. So can you copy a work without multiplying copies of it? In the 19th century, the answer would be, of course not, don't be silly. Now we're not sure, because we have this decision of the Court of Justice, which suggests that if you do what was in the previous picture, you lift the image from one medium and put it on another medium, so at any one time there's only one image that exists. That is an act of reproduction. Because it provides a result closer to the original and is actually sufficient to constitute a new reproduction of the work. This is opaque, I think, even by Court of Justice standards, but I think also it's also interesting in what it doesn't consider. It doesn't consider, first of all, is this process something that's going to harm the value of the right holder's work? It seems not, because in this case, the people doing the image transfers had actually bought authorized copies of those works to carry out the transfer with. Arguably, it isn't anyway. The second thing is that there's complete absence of any consideration of, if you hold this way, if you make this sort of thing a potentially infringing act of copying, what other things have people been doing in all this time, assuming that they were not copying what other kinds of activities would suddenly be caught. I think the UK government submitted in this case that, for instance, people would no longer be allowed to cut out pictures and make collages of images. So, but this does not seem to be, and on an even very small scale, you would think if you still made scrapbooks, would that be allowed? If you rebound the book, would that be allowed? So there are all kinds of activities that this has implications for, but it has not been does not seem to have been considered in this judgment. So maybe one point to push back on. Whatever copying may be a lot of things, but let's draw the line here. Let's stick with copying. At least it has to involve some sort of multiplication. Okay, on that note, thank you for your attention. I hope it has not been too boring. Thank you.